Namaste, sir.
Namaste, good evening.
Good evening, sir.
This is K. Santananda from Secunderabad. I
Yes,
have
sir.
been an advocate for the past 52 years. Of course, Mr. Kalyan has given my introduction. And I also was associated with the Company Secretaries Chapter for 19 years. And with the Murray Chennareddy Institute of Human Resources, I trained up IAS and IPS people and revenue officials. I was with the railways also for 10 years, training up law officers and law assistants on law subjects. I'm an all India examiner for ACS and CIAB, that is bank exams.
Oh, great.
Of course, I have a spanning career of 52 years in the profession. And in fact, I was the junior of my father, Mr. K.R. Kupuswamy Iyengar, who had about 68 years or 69 years of standing. My uncle also had about 57 years of standing. I am following up the tradition. And most of my juniors have become judges. And even in Andhra High Court, I've got my own students as judges also. But one thing I've learned in this profession is not to go for any obligation to anyone. I don't bow my head. I only trust my knowledge. That's all. With that, the brief introduction, I start the lecture. And this specific relief act is divided to three parts. That is today, tomorrow, and day after tomorrow. Today, we are concentrating only on the introduction of the specific relief act. That is only regarding the specific performance of contract. To come to the subject in the proper perspective, the law of specific relief is a species or a branch of the Indian Contracts Act of 1882. As you know, that popularly Indian Contracts Act is called the great grandmother of the entire mercantile laws. And the Indian Contract Act contained in itself the Indian Contract Act, the basic principles, the specific contracts, Sale of Goods Act, Indian Partnership Act, Negotiable Instruments Act, Railways Act, Carriers Act, and the Specific Relief Act. But in the 20th century, the British government found that the act is very verbose and they wanted to shorten the act. And that is the reason the Specific Relief Act was removed from the Contracts Act, and in 1908, the Specific Relief Act was passed. Then slowly what happened was a lot of developments took place, and in 1963, we have the present enactment called the Specific Relief Act of 1963. One basic thing you have to remember is to understand the Specific Relief Act in the proper perspective, we have to compare our law with the laws prevailing in England. After all, in England, we had courts called common law courts. Common law courts were created by the charter issued by Her Majesty, the Queen of England. It contained only three branches. One was Court of Exchequer, Court of Common Pleas, and the Queen's Bench. But curiously, the common law courts never provided for the positive enforcement of a contract or the negative enforcement, that is in form of restraining anyone from committing a wrong. Slowly, equity stepped in, wherein whatever defects were there in the common law was sought to be rectified by the law of equity. In India, we don't have separate law of equity. I think most of you know about it also. But the equitable principles are found in almost every enactment. And one such enactment is the Specific Relief Act. And today, we are dealing with an enactment with a chapter called the Specific Performance of Contract. Here, the specific performance of contract is contained in Section 10 to Section 24 of the Specific Relief Act of 1963. First and foremost is, what is specific performance? Specific performance means and includes enforcement or implementation of a contract and preventing people from going back on the contract. It is called specific performance. That is, a positive enforcement is what is called specific performance. Common law courts never provided specific performance. It only said whenever a contract is violated or breached, only damages used to be awarded and money compensation used to be granted. After all, you know, there's a maxim in law called justice should not only be done, but also deemed to be done. When a person says, sir, the other side has violated the terms of the contract, please compel him to perform his part of the contract. Common law courts used to shut them out by saying that specific performance or positive implementation is not provided by common law courts. Only money compensation used to be granted. Then what happened was, of course, I'm giving you the history of equity. Then a lot of petitions were presented before the Queen, who tried to delegate the functions to the Lord Chancellor and created the equity courts. Equity courts are nothing else than when trust and confidence is reposed in one person and it is violated by the other person, law should not be helpless to see that the contract is implemented both in the letter as well as in the spirit. And equitable principles, it is twofold. One is one who comes to equity must come with clean hands. One who seeks equity must do equity. What do you mean by that? One who comes to equity must come with clean hands. That means there shall not be any suppression, there shall not be any concealment or distortion of facts. All facts will have to be laid bare on the table. Other side should not be taken by surprise. Other side should be informed what is the case he has to meet. And other side should also be given an opportunity of answering the averments that are made by the person called the plaintiff. In other words, specific performance is nothing but positive enforcement of a contract and prevention of any person going back on the contract. That is the reason a big enactment, a big chapter called specific performance is introduced in section 10 to 24 of the the Specific Relief Act of 1963. Then we come to the second thing, that is, one who seeks equity must do equity. What do you mean by that? That means one who wants to knock at the doors of equity and says that equity should step in and provide for enforcement of a contract, he must also be prepared to perform his part of the obligations. That is the reason, if most of you are aware, you have got a section called 53A in the Transfer of Property Act, which provides for part performance of the contract. And one more important thing you must remember is privity of contract. What do you mean by privity of contract? In the basic principle of Contracts Act is contract only binds privies to the contract, and a stranger to a contract cannot sue on the contract, isn't it? That is the reason if you see every document which is drafted, be it an agreement, be it a sale deed, be it anything, we use the word hereinafter called the vendor, which term shall include all his heirs, assigns, and legal representatives and transferees in interest. What do you mean by that? Suppose one of the parties dies before enforcing the contract, his LRs or his children can also maintain an action, come on record, and fight the litigation. In other words, a contract which is made, it should be implemented in the letter as well as in the spirit. We don't make a contract just for fun's sake. We don't make a contract to see, only pay some money. Suppose today I make a contract agreement for 5 lakhs, I pay you 2 lakhs more and sell it for 10 lakhs more. That is not the idea of a contract. Either side should not violate or commit a breach of the contract. That is the reason the specific performance is kept. In India, we don't have separate law of equity, but equitable principles are found almost in every enactment. I think most of you are advocates who have got legal knowledge know that every enactment you choose, you have equitable principles. Then the question arises, who can enforce a contract? Here, not only as privy to the contract, his legal representatives, his transferees in interest, his assignees, or any other person who intermeddles in the way. So he can also come on record and then also try to bring an action. It is twofold. See, it's something like in a normal proverb is kettle calling the pot black. See, the kettle itself is black, but you say it marks at the pot and say, look how black you're looking. Please remember, you must be above board. In other words, it is something like saying that you should be like, your fidelity should be something like Caesar's wife. Caesar's wife had no fidelity, but you have to have fidelity. That is the basic principle of law. So the question is, when you say that the other person has violated the terms of the contract, you should not be the wrongdoer. You should be above board. And the other person should have violated it. Please remember, greediness, avariciousness, or the selfishness leads a person to violate the terms of the contract. Today, I want to go for a property. I make an agreement for 20 lakhs. I want to purchase it for 20 lakhs. But the other person is offered 40 lakhs. Will he sell it for 40 lakhs or will he sell it for 20 lakhs? What is the fun in making an agreement? See, in the mercantile world especially, word of mouth is very important. Now, even if it is in writing, so many objections are raised saying that it's a forgery, it's a so on and so forth. But the question is, who can enforce? It can be a legal representative, it can be a transferee in interest, or it can be an assignee who has stepped into the shoes of the assigner. He can also claim the benefits of contract. What are the things we have to prove and establish in a suit for specific performance? One is readiness and willingness. This is more important because readiness and willingness to perform your part of the contract is very, very important. And to illustrate that, there is a leading judgment which has been followed by the Supreme Court also, AR 1984, Madras, page 24. Readiness and willingness is absolutely essential to prove, to maintain an action for specific performance. Without that averment, the question is your suit for specific performance is not maintainable. Then the question arises, in what types of contracts specific performance can be enforced? One thing you must remember is, in Contracts Act, you have got three things: executed contract, executory contract, and future contract. As far as executed contracts are concerned, a suit for specific performance will not lie. Why? Because the obligations on either side are fulfilled and completed. There's nothing to be completed. What do you mean by executed? Some of the obligations are completed, rest of the obligations have to be done at a later date. To illustrate that, I can tell you one thing. Suppose an agreement of sale is made regarding an immobile property, let us say agricultural land. Agricultural land, just like that, you cannot take it, isn't it? You are guided by certain documents. For example, your agreement itself, localization of the property, looking into the layout, checking up the boundaries, and also getting a survey done, and also taking the necessary clearances, like what is called Dharani, Girini and all, which has got, now it's going to be renamed as Matru Bhumi or something else. Bhumata, rather, sorry. So the question is, you have to see so many things. Or, let us say, you must also verify the documents of title, and also you provide for time, because to get back, to give it to you with possession, tenants are in occupation, tenants have to be evicted. Till all those formalities are completed, the contract doesn't get enforced. But one thing is this, you need not wait for enforcement of a contract. The question is, you can always bring an action, provided it is an executory contract. Please underline the word executory, not executed. In this regard, in my experience in the legal profession, I came across a word called Faroktanama. This is a Urdu word, F-A-R-O-K-H-T-A, Faroktanama, N-A-M-A. What do you mean by Faroktanama? Faroktanama in Telugu, we call it as Vikriya Patram, or what is called sale deed. As far as the sale deed is concerned, there is no specific performance at all. Faroktanama means all the obligations are performed, nothing has to be performed. That is called a Faroktanama. A suit for specific performance will not lie against a sale deed or against an executed contract. And one basic thing you must remember is a suit for specific performance would lie only against an executory contract and not against an executed contract. Am I making myself clear to you, please? Now going further, the further question that arises is, what is the type of right that is available under the specific performance? Here in legal maxim, you have got one thing called ubi jus, ibi remedium. Wherever there is a right, there is a remedy, right? As a matter of right, you can claim a remedy against the other side. But law of specific performance is a discretionary remedy. It may be granted, may not be granted. Doesn't mean just because you have initiated action, just because you have paid the court fee, just because you have come to the court, just because you have knocked at the doors of the courts and then started the legal process, it doesn't mean that the court should wipe your tears and immediately grant you the relief. No, you have to satisfy certain ingredients. What are those ingredients? One is, there is an agreement. Agreement spells out so many things. Then next one is, some of the obligations are performed, and some of the obligations have to be performed at a later date. And you will have to say, I have performed these obligations, and the rest of the obligations are prepared to perform at a later date. So, excuse me. So you will have to clearly plead and prove. Why I'm trying to tell you plead and prove is I draw an analogy to your Civil Procedure Code, Order 6, Rule 2, which says plead and then prove, not prove and then plead. Am I right? So the question is, you'll have to lay all the cards on the table. First one is, you'll have to say there is an agreement. The agreement is in the form of an executory contract. The terms of the agreement spells out these things. These are the terms of the agreement. I have fulfilled my part of the obligations. The other side is a violator. Other side has not performed his part of the obligations. Please compel him to perform his obligations. Right. Then one more thing I try to make it very, very clear to you is this specifically fact is not an independent provision. You got the Transfer of Property Act also, which says 55, section 55 bracket 2, time is not the essence of the contract. We advocates with experience and with knowledge of law try to mingle with words. I think they know an advocate is fond of arm twisting. Without arm twisting, a person cannot be a successful advocate. Am I right? Of course, I'm one among them. The question is, why I'm trying to tell you that is, you have got a separate enactment also called Muddat Ki Kanun, that is called the Limitation Act. Limitation Act, there is one article called Article 4. That the notice is
Then go ahead. No, nothing to, you can go ahead.
not that the notice is going to be replied, but one advantage of giving a notice is you will know the defense of the other side. Other side becomes complacent to say the time is already getting expired. Why should I reply to it? Please remember, it is very, very disastrous because the proviso to Article 54 says it is 3 years from the date when the refusal comes to your knowledge. That is, it means on the day when you give a notice and it is not replied to by the other side, then you get a fresh period of 3 years. Again, in this particular aspect, I try to take you to the what is called the law of contracts. 61, 62, 63 of the Contracts Act says it deals with three principles. One is called novation, another is called remission, another is called alteration, and another is called modification. I think I make myself clear. Suppose an agreement is made on a particular day. Suppose, let us say, just take a hypothetical case, the agreement is made on 21/6/2000. And according to the terms of the agreement, the sale consideration is fixed as 10 lakhs. Out of 10 lakhs, I've already paid you 2 lakhs as advance. Remaining 2 lakhs, I promise to pay next month by a particular date. Then the rest of the money, the entire balance of the sale consideration, I promise to pay on a particular day. But the vendor, what he does is, even after the promised date, he receives the money from me and gives me a receipt. Please remember the last payment which is there itself shows that any lapses that has been committed by me as a purchaser has been condoned by the other side. A novation agreement has come into play, and only the obligations under the novation contract has to be implemented and the original contract gets wiped out. So please remember, in the suit, when you file for specific performance, this has to be clearly pleaded in your plaint. To say original contract was in a particular day, it has been substituted or it has been novated by a subsequent contract, which is this. So I get a fresh lease of life of 3 years. These are all the basic things which comes not by reading books, but by experience, by committing mistakes, committing follies. Everyone commits a mistake, including a judge also commits a mistake. But the difference between an advocate and a judge is an advocate is responsible to his client, but a judge is not responsible to anyone. So you'll have to be very, very careful. Everything is interconnected, sir. Seek, thou shalt find. Only thing is, don't ignore the Contracts Act, because the defenses are also provided in the Contracts Act. And what are the pleadings you have to make? You have to make it very, very clear. So in the limitation paragraph, you also on the cause of action paragraph, rather I put it that way, you say cause of action accrued on so and so date, when the original contract dated so and so should novated, should substituted, should replace by a new contract, and only the obligations under the new contract has to be performed, and the old contract obligations have come to an end. Am I making myself clear to you, please? And the notice also, I called upon the other side to fulfill his obligations or her obligations as far as the contract is concerned. So these things, because I experienced it in one of my suits, where the judge was asking me, sir, why did you sleep for 10 years or 15 years? You did not bring a suit, sir. I have given a legal notice which was not replied to. It amounts to refusal, and a Novation contract has come into play. So I get a fresh period of 3 years as far as the implementation is concerned. Please bear one thing in mind. Enforcement can be done, but it is dependent on certain basic principles. First is, you must say, the contract is at an executory stage. Some obligations are performed, some obligations have to be performed at a later date. I have already performed my obligations, are prepared to perform the rest of the obligations that is cast on me as far as the agreement is concerned. Then it is not a concluded contract. When does it become concluded, sir? Sab khatam ho jata. You say it is executed, possession is delivered, it is registered, finished, everything is over. But it is in the elementary stage where it is not implemented. You want that to be implemented. That is what is called specific performance. So specific performance is not that easy subject to say immediately file a suit doesn't mean that it should be decreed. Then, in all cases, when you file a suit for specific performance, it is the discretion of the court whether to grant you the decree or not to grant you the decree. You cannot come to the court and say, sir, I paid the court fee. I have engaged an advocate of the standing of so-and-so, like Deepthi Reddy or so-and-so. I paid her heavy fees, and I've engaged her specially for this case because she's an expert in specific performance. Please remember, everyone has got his own yardstick, her yardstick also. For me, with my experience, I could tell you, I don't charge less than 1 lakh for any suit. The question is because of my standing, and clients also pay willingly. But when you are new in the profession, please remember we face so many hazards. I also faced. The question is you want your recognition to be there. So this particular lecture today, I'm concentrating mostly on the introduction part of it. Then the question is in all cases, specific performance may not be granted. That is the reason it says that the court, instead of granting specific performance, can grant what is called money compensation, can compensate you adequately by ordering money to be paid by one of the violator to the person whose rights are violated. So another thing is, suppose let us say you are the violator. I told you also you must be like Caesar's wife. Your conduct should be above board. You shall not be the wrongdoer. When you accuse the other person of being a violator, you shall not be a violator by yourself. So these are all the precautions we have to take as far as specific performance is concerned. The doctrine of privity of contract does not apply as far as specific performance is concerned, because even if one of the parties to the agreement dies, his legal representatives can bring an action against the opposite side, or his transferees in interest can also bring an action. That's why we use the word, which term shall include all the legal representatives, transferees in interest, assignees in interest, and so on and so forth. Vagera, vagera. That means anyone can bring an action. Then, what are the things you have to prove as far as maintaining a suit for specific performance? One is readiness and willingness. It is an executory contract. You have performed your part of your obligations. Rest of the obligations are not performed. It has to be performed on a particular date. What are the steps you have taken to perform your obligations? Whether you have given any legal notice, what is the response to your legal notice, and what are the terms of the contract, and whether time is essence of the contract, time is not the essence of the contract. Mostly a clever advocate, what he does is when he drafts an agreement, there's a clause which is included. The vendor hereby agrees and undertakes to execute and register the sale deed as and when called upon by the vendee. What does it mean? It's infinity. I may call upon you at any time, but you have to execute the document. That's the reason we use as and when called upon, to take advantage of section 55(2) of the Transfer of Property Act, which says time is not the essence of the contract. One more thing you must remember is when you draft a suit or when you want to bring an action as far as specific performance is concerned, please read the agreement in clearly. Don't just give a cursory class, just like when you read a newspaper. Daily you get political surveys also. We are not bothered about it. But as a legal man, look into the agreement and try to find out where you can get a loophole, where you can pin the other side, where you can pin the other side by admission, where you can succeed, where you can deliver the goods as far as your client is concerned, because client is our God. Client is I'm not saying you are his servant, but the question is, he pays you vitamin M. For necessarily because he pays you vitamin M, he is expected to get better services from you. Please remember, we don't read a book when we are in the college. At least when we are in the profession, try to. And another thing, the reading of a subject, understanding a particular topic, there are two ways. One is called subjective understanding. Another is called objective understanding. I think some of you who are non-vegetarians know how keema is prepared. That is your non-vegetarian mutton. Say you don't consume the entire leg of a lamb. You just cut it into pieces and make it keema and then prepare it. But in the same way, when you prepare a soup, when you prepare a plate, try to analyze every word. And that is the reason subjective means just blah, 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 subject. But objectively means what an agreement means. What are the terms of the agreement, how it has to be implemented, how it has to be understood, how it has to be brought to the notice of the court, and how you have to impress upon the court that you are the person who has been violated, the other person is a violator. So the question is, in every case where you file a suit, doesn't mean court can immediately decree your suit. Court has to look into it carefully. Court has to see what are the terms of the contract. Court has to see whether the readiness and willingness, whether you are prepared to perform your part of the contract, what are the terms of the contract you have performed, so on and so forth. This is as far as enforceability is concerned. As far as law of limitation is concerned, we are governed by Article 54 of the Limitation Act. When the time is fixed for performance of the obligation, it is 3 years. When no time limit is fixed, it is 3 years from the date when the refusal comes to your notice. That is Article 54 proviso. Then what is the advantage of using the word as and when called upon? That means time is not the essence of the contract. Then you must have seen in certain types of agreements where, let us say, survey has to be done, localization has to be done, your plot has to be fixed, your layout, it should be according to the layout, and you have to be put, kaddi stones are also to be planted, so on and so forth. So many things are there. Then the question is, or consent of a neighbor has to be taken regarding certain things, right of ingress, egress, and all. So unless, of course, you don't have the urban land ceiling now. Previously, urban land ceiling was there. You must see that comes within the ceiling area. Or suppose necessary clearances have to be taken for the governmental authorities. The clearances are obtained. This takes sufficient time. Then in that case, you can try to take advantage of that. And most of you know that during COVID time, all actions were suspended for a period of 2 years. There was no limitation as far as COVID times were concerned. You can always maintain an action after the COVID subsided. So these are all the things we have to bear in mind. I think we'll have a break of 5 minutes and then yes. Thank you.
Any questions on the in this particular issue? Till the lecture has happened right now, as of now. If any questions, please raise your hand so that we will be answering it.
Sir, I have a question.
one person at once. Please, you can.
Can I ask the questions?
Yes, you're welcome.
Mr.
Thank
Swami.
you, sir. Yes, sir. Thank you, sir. Sir, wonderful lecture, sir, and we are getting the benefit out of it. I am a final year law student. I might be not very good at the subject or act, but I would like to seek your guidance.
Sir,
I-
shall I interrupt you 1 minute, sir?
Please,
See,
sir.
one thing is this, you may not be successful in other lines, but as far as the law profession is concerned, mostly unsuccessful people only come to the legal profession. Take my own case. I'll give you my own instance. That 1 minute. My own instance is I was only a pass class as far as graduation was concerned. I was a happy-go-lucky person. But when I came to law, I got a distinction in my LLB, and LLM also I got my distinction. And the very college where I studied, I lectured in the same college, and I faced so many instances also. So the questions don't be carried away by that. No one is perfect, sir. Every one of us is a learner. Even today, in spite of my practice, I still consider myself as a learner. Yes?
Yes, sir. Thank you, sir. Thank you for your enthusiasm. And
Yeah, yeah.
I see that so much of enthusiasm with which you are trying to give us the knowledge. Greatly appreciate, sir. Thank you very much. Sir, my question is, I have filed a OS suit, original suit for the partition
Yes.
between myself and my brother. But
Right.
putting things now in short, they are not ready to do certain things as expected in our written agreement. So then we went for the OS partition suit. Now the question is, sir, they are not paying any maintenance because I am only maintaining that particular apartment,
Right.
big apartment with 15 flats, and they have 50% stake. Now, since they are not giving any maintenance, and I am taking the entire maintenance myself, including not a single pie they are paying.
Right.
And they have bachelors, they have given it for rent, and I have given it for family. So they feel that anyways, this fellow is obliged to do it because the family people will not, they will be more to be taken care kind of thing. So now, as part of the specific performance is concerned, sir, here, I am planning to go for some injunctions wherein I can seek the court. I wanted to know how the specific performance can be utilized in this contest. Kindly,
Sir,
please.
are you an office bearer of the association, sir? Society?
No, sir, not any association, because it's a we two people who own that. My father's ancestor, my father's property is given by will.
Right.
And we have gone through a written agreement, but it is not official. On a white paper, we said that this is your flats, this is my flats.
Swami,
But that
sir.
didn't work
Swami,
out.
sir,
Though
sorry
we
to
are
interrupt.
occupying as per that agreement is concerned, but they are not performing. Now the case is in the court, in the OS. But can we go
Sir,
for
as far as this is concerned, it has nothing to do with specific performance, sir. Only thing is your file in a partition suit, what you have filed, you can amend your plaint and ask for their proportionate share of maintenance to be paid. And whatever amount you have paid on their side also, you can ask that amount to be reimbursed.
That anyways I have put in my plaint, but this will go for years together. And
No,
I'm not getting any relief right now.
Swami, sir, we will certainly speak on this particularly and on one-on-one. The class is getting disturbed. Other people need to give it a chance.
Got it. Thank you, sir.
Thank you.
yes, any?
Ravindra Babu Garu, you are raised your hand for any questions?
Okay, sir. Namaste, sir. I am Ravindra Babu, sir.
Ravindra Babu garu, Cheppandi.
Sir, actually, I thought of calling you to meet you next week. Just I logged in and I found you here. Immediately.
We'll
So
see.
nice.
Anybody else have a questions here?
Sir, one point is there. That sale deed you told, sir. In that it is executed contract. Suppose in that they will be mentioning some points that if any dispute is there.
Will you excuse me for a minute? I'll
Sir.
concentrate last 15 minutes for interaction, sir. Please.
All right.
That's why I lowered my hand.
So kindly note down.
Narendra
Kindly,
Babu garu ఒక మీరేం చేస్తారంటే write down your questions. Definitely we'll see. And Nageshwara garu, you are asking some questions. Please unmute yourself and please go ahead.
Okay, sir.
Nageshwara garu, please unmute yourself. Unmute. Please unmute yourself. I'm not able to hear you. Please unmute yourself. Please unmute yourself. I'm not hearing you. Yeah, I'm audible. I'm audible.
Now this is coming to you.
yes, sir. Yes, sir.
Namaste, sir. I am Y. Nageshwara from Dialbag, Agra.
Yes, sir. Tell me, sir.
No, because as a matter of fact, now you are going in an introduction class, and that therefore I do not want to raise any question.
Yes.
But one point, let us, for the purpose of our friends, what is to be clarified is regarding the time as essence of contract, and what is the application as far as the time is concerned in the case of immovable properties. That is,
Sir, I will answer your question in last 15 minutes, sir. Please.
All right, sir. Nageshwara garu.
that's why, because
kindly make a
Make a note of it. We'll definitely question.
at the end of session, I will.
Yes, sir.
Sure. VC, somebody has raised VC. The last one, sir.
Yeah.
VC.
I am Madhav Rao, advocate, High Court. Actually, my client, they executed the sale agreement, and during COVID, they could not complete the specific performance. But it was filed just before 3 days on the, before the completion of the 3 years. Means that judge is saying that the time is over. Is there any
let us have 5 minutes.
relaxation during the COVID period? Is there any?
Sir, there is a circular issued by the central government that for the period of 2 years, the period of limitation stands suspended.
Okay, is there any GO or something like that?
No, there is a circular, sir. I do not have the reference immediately, but
Okay.
there is a circular issue.
There is a circular issue.
Yes, sir.
Okay, sir. Thank you. Thank you very much.
Thank you. Anybody? Shall we go ahead with the class?
Yes, sure.
Okay. Sir, please mute yourself, sir. Sir, go ahead.
So we are on the point of enforcement of a contract, enforceability of a contract. First and basic thing I don't want to repeat. It says that suit for specific performance lies only against an executory contract and not against an executed contract. I'll try to amplify it. Where it is in the form of the formative stage, some obligations are performed, some obligations have to be performed at a later date. That is what is called executory contract. Executed contract means where the obligations on either side have been completed, nothing has to be performed. It is called an executed contract. Future contract is where the rest of the obligations have to be done at a later date. It is called a future contract. But you cannot maintain an action regarding a future contract immediately before the arrival of that period. Am I making myself clear to you, please? Now going further, it is a discretionary remedy. That is, I told you also that you must be above board and you must be like a Caesar's wife and you must not be the violator. The violator should be the opposite side. Then alone you can maintain an action. And action can also be maintained by this legal representatives, transferees in interest, assignees, successors in interest also. So it is not necessary that only a party to the contract can bring. It is an exception to the rule of privity of contract. Then it is a discretionary remedy. I told you also, one who comes to equity must come with clean hands. That means there shall not be any suppression. There shall not be any concealment. There shall not be any distortion. All facts have to be laid like a pack of cards, and the other side should not be taken by surprise. And it should not be barred by any law for the time being enforced. Why I'm trying to tell you that is, the question is, sometimes, in India, a law is born every day. When we studied, we didn't have so many laws. PMLA, COFEPOSA, so on and so forth. It has come recently. Money laundering is a hot topic now. The question is, let us put it straight. that that's why I told you we are a learner every day. Every day new laws are coming. And our brain is so small, it cannot take everything. It is not a dustbin where you can store everything there and throw the rubbish. What is rubbish and what is good, we do not know. Also, we cannot separate it from that. So question is here, if discretionary remedy, what does it mean? Court may grant, may not grant. Just because I told you, Mrs. Deepthi Reddy is there. She is a big, let us say she's a big advocate. She charges very high fees. I pay her about 5 lakhs or 10 lakhs for a suit. I cannot say, sir, I approached the biggest advocate, Deepthi Reddy, paid her 10 lakhs, I paid the court fee. Please give me the decree. Please remember, it's not something like going to a sweet shop and purchasing sweets and then swallowing it. You have to satisfy certain basic requirements. And that's the reason I told you that if to understand specific relief act properly, you must have a thorough knowledge of its great grandmother. That is the Indian Contracts Act. Indian Contracts Act, I could tell you, is a great grandmother of all laws. Being a specialist in mercantile law, I could tell you, without knowledge of Contracts Act, you cannot understand the mercantile laws that are prevalent today. So the question is, each one has got his own way of understanding. I could tell you, one way of understanding a section, one way of understanding a subject is, when you come across a section, don't read it subjectively, read it objectively. What does it mean is, take out every word. Try to take out the dictionary, know the meaning. And like an orthopedic surgeon, join all the meanings together, you understand the subject better. One more way of understanding a section is, go through the illustrations first and then come to the section. Or another way of understanding is, go through a case law that is given as far as that particular subject is concerned, section is concerned, then you understand it. So this is what is called the American system of study of a section. That is what is called balkanizing a section into fragments and then joining all of them and understanding it like an orthopedic surgeon. That is what is called objective way of learning. I could tell you the best method of understanding is the American system, where we try to balkanize a section, try to know the meaning of every word that is used, and then try to join all of them and understand the subject better. But if you read from the first word to the last word of a section, you do not go anywhere. That is, in Telugu, they say, Antam Kadidi Arambam. Where it has started, where it has ended. Something like now the modern day films. You don't know where it starts. Right in the beginning, it will be the same. In the middle, in the interval, it will be the same. The end also will be the same. So the question is, objective way of understanding a section is very important. I'm not only talking about specific relief act. It can be any enactment. Any enactment. Just read it in an objective way. If you read it in an objective way, you can understand the subject better. And one more thing, don't forget the knowledge of Contracts Act. Because Contracts Act, certain basic principles are there which are not in specific relief act. I told you just now, novation, remission, alteration, modification. So the question is, when you write the cause of action paragraph in a plaint, you will have to clearly state the original date of agreement and then say how it has been substituted, what are the substituted clauses, how does it give you the period, extended period as far as limitation is concerned. All those things will have to be clearly pleaded, because again take you to CPC Order 6 Rule 2, plead and then prove, not prove and then plead. Am I making myself clear to you, please? These are the basic positions we come across in our day-to-day practice. This comes mostly by experience. This comes mostly by practice. This comes mostly by committing mistakes. This comes not by reading books. Various books you may read, but still you come to the square one. So objective way of study of a section, be it any enactment, is very important. I advocate a person's knowledge or objective way of thinking rather than subjective way of thinking. Subjective is blah, 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 right? From the first word to the last word, you read it as a paragraph. You don't go anywhere. If you still want to make it easier, look into the illustrations, look into the examples that are given, look into the precedents that are given, look to the commentary that has been given, then come to the section, you understand it in a better way. Yes? So this only I wanted to convey to you Any in interaction, any questions you can ask, you are free to ask.
Today, as of now, the class, first class, first day introduction is done as of now. There are a lot of other things will come up tomorrow, day after tomorrow. If it is required, we'll day for one more day also. Because the act which is being given, it is, you can say that mind storming and mind boggling also sometimes. You can say that. So it's a very small act as we know it, but it has a lot of complications, as everybody knows. So now the question here starts and interaction starts with you. Any questions? Please raise your hand first and then question. Anybody? Any questions further? As of today?
Hello, sir.
Yes. Chapandi Ravindra Babu garu.
Sir. Nice, sir. I have given how to read also a section. We will try to practice, sir. Then, sir, one question is in the executed sale deed, generally we will put one condition that if there are any future disputes, we will
Indemnity clause.
indemnity. Then we can say it is a fully executed contract, sir.
No, in that case, you can always lay a claim for money. Invoke the indemnity clause and say you have agreed to indemnify. These are the defects which you did not disclose at the time when you executed the contract. Now these defects have come into the fore. These are the defects. Please rectify it and compensate me as far as money compensation is concerned. Right?
So that is part of contract. And sir, can we say that contract is completely concluded?
Even if it's concluded, if let us say there are some defects in the property or defective title, that indemnity you can invoke and try to get the money, whatever expenditure you have been put to.
Yes, sir. Yes, sir. But technically, we call them as executed contract.
No. Right? I think you are able to understand the meaning between executed and executory.
Yes, sir. Yes, sir. Executory means to be done in future.
That's why I tell you, because in one of the cases I came across a word Faroktanama. That's a Urdu word. That is me Telugu Vikreya Patram antaru. Vikrayam అన్నిటికీ అంటారు. అగ్రిమెంట్ ఆఫ్ సేల్ కూడా విక్రయ పత్రం అంటారు, సేల్ డీడ్ కూడా విక్రయ పత్రం అంటారు. విక్రయం అనేది ఏంటంటే బేచి అంటే అమ్ముడు అమ్మేది. విక్రయ పత్ర ఒప్పందం అని ఉంటుంది. దట్ మీన్స్ అన్ అగ్రిమెంట్ ఆఫ్ సేల్.
అగ్రిమెంట్ ఆఫ్ సేల్.
సో ఉర్దూలో ఫరోక్తనామా అంటే సేల్ డీడ్.
Yes, sir. Nice, sir.
Executed contract.
Nice, sir.
Okay. All right, sir. Nageswara garu, you are asking certain questions.
Thank you so much, sir. Kalyan garu, thank you.
Thank you, sir. Sir, you are asking some questions, Nageswara garu.
No, right now, can I put this? Sir, can a plaintiff in a suit for specific requirements compel the defendant to prove his title first before that?
Sure. As far as the question is, plaintiff cannot ask the defendant to prove his title. When you have entered into an agreement, because you have got a doctrine of in the Transfer of Property Act itself called doctrine of Cave Temptor, buyer beware. When you try to purchase a property or try to enter into an agreement, you have to go through all the documents, and also you will have to find the flow of title. You will have to find how the property has come to your vendor. Yeah, whether it's by sale, whether it's by gift, whether it's by transfer, whether it's by will, whether it's by court decree, or whether it's by partition decree, so on and so forth. We have to make all inquiries possible. If you are not able to get those information, you can call upon the other side to furnish that information by a written notice. You cannot ask him, you prove your title, then I'll purchase. No, I'm sorry.
He is not entitled to deny the title of the defendant.
No, elagu undante. I'm only, of course, in a humorous way. When you acquire a bride, sir, 1 minute. When you acquire a bride, you go to see a bride. I think you have crossed that age of marriage. But anyhow, when you want to see the bride, you try to see the social background, financial background, the reputation in the society, how the family is, so on and so forth. The same way, when you purchase a property, you have to take all precautions possible. That's the reason why doctrine of Cave Temptor is there. Buyer beware. That is the reason. Don't mind going to an advocate like you and then trying to take a legal opinion and then come to a proper conclusion. The question is, you cannot say, Mr. Defendant, you prove your title. You want that defective or not defective, you have entered into an agreement. You want that agreement to be enforced. Or let us say, I put it this way. I think what you're trying to drive at is, survey has not been done, your plot has not been localized, or your boundaries have not been fixed. You can always make an application to the court, sir, please ask the revenue authorities to depute a revenue inspector to demarcate the land, localize the land, they make use of the Google map, and then fix my boundaries. You can always do it.
There, as a matter of fact, we cannot generalize the issue.
You
But
cannot.
actually, now the problem is you are at the point now.
Yes, sir.
The agreement has been executed for certain extent of property,
Right,
and
right.
subsequently, by the date of execution of the sale deed, the survey numbers was found to be incorrect in the agreement, and suit for specific performance has already been filed.
Right.
A commission is appointed and localization also is made, and surveyor found the property in 2 different survey numbers.
Right.
Now, the defendant wants that the plaintiff should first prove his title and thereafter only he has to execute the sale deed. What we are saying is, if he wants to get the sale deed, he can get the sale deed to the extent covered by a particular survey number mentioned in the agreement, or otherwise he can rescind the contract.
I'll tell you, sir.
But
I'll put it this way. One of the questions that arose in the JCJ's exam and other exam was, suppose let us say there is an agreement to sell 150 acres of land. Put it this way. I am the owner only of 100 acres. 50 acres does not belong to me. It belongs to Mrs. Deepthi Reddy. Then I said, I'll try to satisfy her to sell that 50 acres. On the day when I make the agreement, I had no title regarding the 50 acres of Deepthi Reddy. 50 acres belongs to her. She may be your sister, she may be your sister-in-law or anything. But still, as far as 100 acres are concerned, you can get a sale deed executed. There is no doubt about it. But as far as the 50 acres is concerned, you have to convince the other side, that is Deepthi Reddy, to execute the document. But here, if the entire consideration is paid for 150 acres, let us put it that way, and the assurance given by the seller that we shall try to convince Deepthi Reddy to part with that property. The question is, suppose she doesn't do it, the person who has made the agreement has to compensate the other side with damages.
But one thing, you cannot expand the principle, but the law says that latent defect only need to be disclosed by the vendor. But at the same time, a defendant cannot cast
No, defendant cannot
the vendor himself.
No.
That is the problem.
See, sir, one thing is this. The pleadings which are made nowadays, of course, I'm not singling out anyone. You can write anything and everything because pleadings are not written by advocates, it's written by the typist.
You are 100%. I agree. I agree. You are 100% correct because they are not in a position to draft and they are not minding the form.
Cut and paste.
Even after the amendment, what has been the difference to now? Readiness and willingness need not be pleaded, but we can prove it. That is the contemplation of amendment.
Latest amendment to specific relief act is readiness and willingness also need not be proved, need not be averred.
It need not be averred, but earlier under Form 47, unless we aver it, this would have been rejected.
Exactly, that is AR 1984.
That is the earlier position.
Right.
No.
There is once an agreement is set up, it is deemed to have been proved.
Even in case of essence of contract, also in the immovable property,
So that
usually
is
that is not the essence of contract.
Sir,
But,
Mr. Nageswara, it's only advisable that when you draft out an agreement, you take the signatures of 2 witnesses. Because the question is,
Yes.
one of the commonest defenses are, it is not my signature, it is not executed by me, it's a forgery, so on and so forth. But you try to prove the signature of a person by examining the attestants who say that in my presence, the signature was put. We are acquainted with the signature of so-and-so. This is the signature of A, and we have witnessed the signature.
Yes.
Right? And one more thing is Pardanishin ladies, especially Muslim ladies, they don't come out in the open. What they do is they stay behind the parda, and their document is read out. And in the presence of the witnesses, the document is read out, and that lady says, kubule, kubule, kubule. That means I accept whatever the terms are mentioned therein. So that question is, you can prove it only by examining the attestants.
But
Yes.
if this, it is so related, but not in the point of view of section 68 of evidence.
And one more thing
Proof
must
of
remember,
evidence. Because
one more thing,
I like your approach, sir. That is the reason why, for the sake of juniors, I am interacting with you.
sir, one more thing I should tell you, sir. There is one provision called Article Section 91 of the Evidence Act, Samhita Kanuni or whatever it is. There they say witnesses may lie, but documents do not. You cannot lead oral evidence against a document. When the terms and conditions are contained in a document, if you want to lead liberal evidence, it should be cogent evidence.
It is totally accurate, but because
Exactly.
against the document, we cannot subtract,
We
we
cannot-
cannot add, or we
Exactly,
cannot
exactly.
supplement, or we cannot do anything.
Exactly.
Except in the case of will only under section 100 provided.
Right, right.
But nowadays we are seeing the plaint where, and we are also seeing the chief examination of fluids, as now you said, that even a document which is optionally attestable also is being proved as a compulsorily attestable document.
Sir, when the CPC was amended, I was the first critic of the amendment, sir. Because the question is, originality goes once the evidence affidavit is filed. Am I right?
No, yeah, 100%.
And another
Because-
thing, sir, sorry state of affairs is, cause of action, court fee, prayer, everything is there in the evidence affidavit. There's no seriousness.
Nothing. Even if some plaints, I think your good selves also might have come across. Our junior friends are, even some senior friends also are writing cause of action for the suit arose when the defendant entered into contract with the plaintiff.
Right.
We do not know how it would be the cause of action. That's why I have feeling that when the plaintiff has come, the refusal of the performance has come to the notice of plaintiff only, where the time has not been the essence of contract fixed by both the parties.
Then novation.
Sometimes if there is another evidence to show that the plaintiff is having refusal of specific performance of the contract from the side of the defendant, even notice also does not show the limitation. These are all things our friends are not observing.
Article 54 proviso, Article 54 proviso, and Section
first of all,
55
second
of the
part.
Transfer of Property Act. If a person goes through it carefully, there are catena of decisions which says time is not the essence of the contract.
Yes.
But one thing is this, question is your pleadings should be carefully drafted.
Yes. So it should be.
Sir,
Right, sir. Thank you very much. For the
You're
sake of
welcome.
juniors only, I interacted with you.
You're welcome,
Not to put any question because I like.
Where are
your
you practicing, sir? Where are you
behind
practicing?
the lecture.
Where are you practicing, sir?
I practiced at Kakinada for more than 37 years in
Okay.
AP. Now, right now, I am affiliated to Rajasthan Satsang Association. And I switched my practice to Dayalbagh. Dayalbagh, Agra. I am working as an officer in Dayalbagh now.
sir, 1 minute. DS Rao garu. DS Rao garu. DS Rao garu. DS Rao garu. DS Rao garu.
We deal with Yugandhar sir, Upendar sir, who is online.
గౌస్ సార్ ఎవరు అడుగుతున్నారు విఎస్ గారు అడుగుతున్నారు క్వశ్చన్స్
Sir, can you please explain the difference between future contract and executory contract, sir?
Yes. See, as far as executory contract is concerned, some of the obligations are performed and the rest of it has to be performed at a later date. That is what is called executory contract. Future contract means, suppose today, let us say we have agricultural season, isn't it? Rabi season and then Kharif season. As soon as I get my crop, today I will sell you 500 bags of quintals of rice. And as soon as the new crop comes, I will sell you that 500, remaining 500 quintals. That is 1000 quintals I'll supply to you. Today a contract is made, and regarding the future, when I get that 500 bags, I will sell those 500 bags to you. Rate is also fixed. That is what is called a future contract. Am I making myself clear to you, please? Yes?
disconnected I hope so. Madam VC garu, sir, you raised a questions, raise your hand. VC garu, are you there, man? Sir,
Hello.
sir చెప్పండి.
Sir,
Yes, sir.
I am Srinivas from Guntur.
Right, sir.
Sir, my doubt is,
Yeah.
after the buyer purchases the property from the seller, After execution of the sale agreement, subsequently the seller sold away the same settled property to third parties.
Right.
That third party also alienated the property to some other ex party.
Okay.
So, within the limitation period, the first buyer filed the suit for specific performance.
Right.
Then, what is the plaintiff has to seek the relief against the subsequent buyers of the said sale agreement in favor of the plaintiff.
See,
So, it has to seek the declaration or what about with regard to the position of the scheduled property?
you must ask for a declaration that the sale deeds which are executed later on is affected by section 52 of the Transfer of Property Act, list pendants, or also say make them also parties to say that they should join the original defendant in execution of the document conjointly with the first defendant or what's
execute the sale deed in favor of the plaintiff.
exactly. But you can't ask for cancellation because you are not a party.
You
can
are
only
not a
ask-
party to the said sale deeds. Correct.
Exactly.
So that it comes under the 24 of
24D.
Yes, sir.
24D.
24D. Okay,
Yes,
sir.
Right.
Then what about the position, sir?
Possession also you can ask because they say declaration and possession.
24A.
Yes, sir.
Okay, thank you, sir.
Right, sir.
చెప్పండి వీసీ గారు, మీరు ఏదో అడుగుతున్నారు క్వశ్చన్.
అడిగారు
మీరు మళ్ళీ ఏదో క్వశ్చన్
yes.
I'm unmuting. Yeah. Actually, there are.
Yeah.
Hello, could you hear me, please?
Yeah, please go ahead.
Yeah, there are father and his two sons. They executed the sale agreement. After that, father had passed away.
Right.
Passed away in Hyderabad.
Right.
Whereas his, father has written a will, registered,
Right.
and the property belongs to his wife.
Right.
Okay. In the meantime, mother and two other sons, they are selling the property to third party.
Right.
And in the third party, they are not mentioning regarding the will.
Right.
They are mentioning that, by producing the family certificate,
Right.
they are executing the sales.
Right.
Okay. And they have given the WST, written statement.
Right.
Whatever is mentioned in the WST is quite different from the actual sale deed. What has mentioned in the sale deed is that his father died without, intestate.
Without leaving any will.
Without leaving any will.
Right.
Whereas in the same sub-register office, the will is registered.
Right.
But these people are saying that he died with an intestate.
Right.
So is there any possibility that these people can be caught based on that?
Only thing is variance between that document and the will, actually, isn't it?
But
you said that there was no will at all.
they are saying, no, not me. They are saying that there is no will, and based on that they are selling through the sale deed in the same SRO.
Okay.
Whereas in the written statement to specific performance, they mentioned that there is a will, and based on that will, the property belongs to their mother and the two of them.
See, the earlier transaction doesn't get wiped out by the will, sir. Because earlier there has been an arrangement between the father and the two sons to sell a particular property to your plaintiff, whosoever it may be. And will has been done only to overcome that particular transaction, isn't it?
Father gave the will to his wife, and wife is also one of the party to the subsequent sales.
Right. The question is you'll have to challenge the will also. To say will is non-est because of the earlier transaction.
No, the will is there. The will is there. The will is there with the plaintiff.
Right.
Plaintiff got certified copy of the will from the register office.
So you can challenge that will.
No, we do not want to challenge that will. We want that whatever the documents they have registered by saying that it is an intestate, we want to get them cancelled.
Acha, acha. They have to say that will to be cancelled.
Yeah, will not to be cancelled. Will is registered already, and we cannot get it cancelled because it was during his lifetime.
Okay.
So,
It will come into effect only after his demise.
pardon?
Will come into effect only after his demise.
Yeah, he passed away after
He
his
passed
passing.
away. So will has come into effect.
Yes, correct.
So now the question of challenging it comes now only when it has come into effect. That registered will has to be challenged.
Yeah, it has come into effect.
Yeah,
And
it has to be
whereas-
challenged.
Excuse me. Whereas these people are bypassing the will and selling that.
You can take an injunction not to sell the property.
No, we have filed that, and the judge is not giving the injection, temporary injection also, saying that out of the three actual, parties, defendant number 1, 2, 3. I mean, one is here in India and 3 is here in India, and they filed the written statement. And D2, he is residing in US, and he is not. I mean, the judge is not allowing us. I mean, to go ahead with the. Hearing also. He is postponing it for the last 1.5 years.
But that only things are better. You amend your plaint and say challenge the will.
And finally, we have asked him to serve the notice through WhatsApp and email also, but that also he is postponing. And now the holidays have come, and he says that okay, after the holidays, I will look into it. Yes. He is just postponing it for the sake of postponing only.
Yeah. Sir, that is the order of the day everywhere, sir. Unfortunately, we have to blame the Supreme Court, where they say even 1 day's practice is enough to become a judge.
Right.
You need not even have 1 day's practice also.
And what has happened is we filed that CRP in High Court, Amravati.
Right.
Asking for directions from the High Court to
the matter.
To speed up the issue. And unfortunately, that judge retired this month today.
Okay.
So it will be had later. I'm not.
Right, sir.